Defense closing argument, United States v. Sean Combs delivered with clarity, constitutional passion, and grounded legal authority. May it please the court. Ladies and gentlemen of the jury, you have been summoned, not just to decide the fate of one man, but to decide the reach of the law, how far we are willing to let public pressure, outdated statutes, and retroactive regret stretch the definition of justice. This is not a case about trafficking. This is not a case about racketeering. This is a case about reputation, sex, and power, and how easily they can be manipulated. What you've heard over these past weeks is not the story of a criminal enterprise. It's the story of a powerful man with complex personal relationships, emotionally entangled partners, and a media microscope that turns every whisper into a scream. But scandal does not make a crime, and kink does not make coercion. The government wants you to believe that Mr. Combs, an artist, entrepreneur, and cultural icon, secretly ran a sexual trafficking operation masked by fame. But they have not brought you a single piece of evidence showing a structured criminal enterprise. They've brought you old text messages, hazy memories, and emotionally charged language designed to ignite outrage rather than uncover the truth. Let's be clear about what the law requires, and why this case fails. RICO, under Turcotte, requires more than chaos. It demands a functioning unit with continuity and a shared criminal purpose. What the prosecution calls an enterprise was a chaotic entourage of adults, each acting for their own reasons: access, love, opportunity, or status. There was no coordinated effort to commit crimes, no profit split, no command structure, just private decisions, made behind closed doors by consenting adults. And sex trafficking, under Section 1591, is not about bad relationships. It's about coercion. It's about real force, real fraud, or real threats. The law is meant to protect victims of slavery, of fear of no escape. Let's compare. In the Asian forced labor cases cited by the government, workers were forced to labor 7 days a week, lived in austere housing, were deprived of liberty, and paid next to nothing. There was no vacation, no romantic dinner, no spa weekend, no 5 months without seeing you text. There was no break from the pain. Now ask yourself, do Cassie Ventura and Jane Doe sound like they were in that kind of hell? Or do they sound like adults navigating toxic, high-risk, but voluntary relationships filled with luxury, status, and yes, shame? Jane Doe stayed for 2 years. She received housing, jewelry, travel, and even signed a contract, a love contract, 2 years after the supposed abuse began. That's not conveying to the defendant the necessary knowledge that you do not consent to the sexual hot wife and cuckold power dynamics. And that's not the conduct of a person being trafficked. That's the conduct of someone trying to negotiate her place in a world she chose, even if that world was strange, even if that man was powerful. Have you ever considered why Miss Jane Doe was granted immunity with respect to her name and identity? Has she ever been in a shakedown money grab relationship like this before? Prosecution. Objection. Judge response. Fill in. Let's talk about Cassie Ventura then. Her story began and ended years before Jane Doe's. There is no continuity. There is no network. These are isolated, emotionally complex relationships, not criminal acts strung together to form a federal case. Honey traps are exotic Asian baddies that steal, manipulate, extort and blackmail rich and powerful men. The victims here are the baby mothers and housewives that have actually dedicated their lives to such infamous and powerful men. You've heard the story before. The average-looking, real, domestic woman to which these powerful men are attached by familial ties lose their husbands and baby's father to these exotic, exceptional beauty types. Mr. Combs is the target of such women because of his personal failing, not because he's a crime boss of sex trafficking. Did Cassie ever fabricate any testimony as to alleged gang rivals for this type of clandestine luxury call girl lifestyle? No, because there is no such gang or organization that works crimes for no profit motive or value to further the alleged criminal enterprise. As my colleague said, give Mr. Combs a little more credit than alleged by these types and the prosecutors, because you have to ask yourself, where all the celebrity freak-offs, minors, trap houses for sex workers, money, drugs for distribution, stock of guns, militias, and muscle fantasized in the indictment? Where are Ms. Ventura's, or Ms. Doe's, handcuffs and shackles? Why aren't they kidnapped from their respective families and chained to a pissy mattress in some undisclosed tenement, deep in the bowels of the hood? Why aren't they not restricted from communication devices? Why, if Ms. Ventura is so fear-based traumatized, does she have access to publish a single about her ordeal in a less dramatic inference? Why does she have access to media and a public platform to tell her ordeal? Because it never happened. Imagine if one teenage or adolescent had any of the things Ms. Ventura or Ms. Does have during these past 20 years of alleged trafficking. In fact, Imagine a real trauma-bonded child having just 20 minutes with a cell phone to ask for help. Yet, you expect this jury to swallow this fabricated and sophisticated scheme, that no police reports in over 20 years of crime boss activity ever resulted in one call for help. A child would risk everything, including life itself, for 2 minutes of access to a cell phone to get help. Now before you, today, appeared two grown-ass women and friends, and no staff know about these parties except these drug-addicted, financial opportunists that have wasted nearly 4 weeks of your time. Ladies and gentlemen of the jury, prosecutors, objection, judge response, fill in. Please forgive my passion. My client's life is at stake here. The lives of his family sitting behind him will be forever changed, and irreparably harmed by these proceedings already. The damage is done. It would be a disservice to the interest of justice and fairness to find my client guilty of these fabricated lies is orchestrated sensationalism. And what of the Mann Act, a law born in 1910, used to prosecute interracial relationships and consensual sex cloaked in moral panic? It's being resurrected here to criminalize the appearance of sexual favoritism and proximity to fame. But the evidence shows, women traveled to see Mr. Combs for lifestyle, for music, for romance, not for payment, not for contracts, not for prostitution, and not one of them was kidnapped, not one was locked up, not one said no and was physically forced to say yes. Ladies and gentlemen, this is a case of legal overreach, not criminal enterprise. You've been shown the aftermath of broken relationships, and told to believe they were blueprints for slavery. But the law protects us from exactly this, from redefining private consensual behavior into something criminal just because years later, it no longer feels right. If we accept this prosecution theory, then every powerful person who has loved imperfectly, who has kept secrets, who has had sex while famous, can now be called a trafficker, and every adult who chooses luxury, who accepts a gift, who trades access for experience, becomes a victim. That is not justice, that is narrative, and the courtroom is not the place for narrative justice. Give a one-line transcript testimony from each of the material witnesses that caused a red flag of reasonable doubt, or incredulous inference. Closing summary. Attorney 2, let me leave you with this. If there is no coercion, if there is no shared criminal intent, if there is no pattern of profit, then there is no crime. You must not confuse regret for rape. You must not confuse secrecy for slavery. You must not confuse a scandal for a scheme. This man is not a pimp. He is not a trafficker. He is not a criminal mastermind. He is a flawed, famous, highly sexual man. And that alone is not a federal offense. So I ask you, find the courage to say not guilty, not for him, but for the next person whose private life may be dragged into a courtroom under the guise of justice, when in truth, it's vengeance dressed as law. Let the law be precise. Let your verdict be just. Not guilty. Thank you. Would you like this saved as a formal PDF brief, or formatted for courtroom printing, or podcast narration? Here's a refined summary of the prosecution's closing arguments in the United States v. Sean Combs trial. Bullseye. Prosecution's core narrative. 1. Diddy as crime boss. Asa Christie Slavic described Combs as the leader of a criminal enterprise, built on power, violence, and fear, not personal failings. She pointed to his inner circle, assistants, bodyguards, and staff, as his small army, enabling racketeering acts including bribery, arson, kidnapping, drug distribution, and obstruction. 2. Sex trafficking. Freak-offs as coercive events. Prosecutors portrayed freak-offs as drug-fueled sessions, where women were forced to have sex with escorts, often while under duress, or after physical assault. They emphasized that even a single coerced encounter suffices for conviction, citing testimony from Cassie Ventura and the pseudonymous Jane. 3. Physical and psychological coercion. Specific incidents were highlighted. A 2016 video showing Combs beating Ventura in a hotel, an alleged assault on Jane involving choking, and forced post-fight sex. The prosecution argued that Combs threatened the release of recordings and manipulated women through drugs and money to ensure compliance. 4. Use of staff and infrastructure. They argued Combs used airline tickets, hotel bookings, staff coordination, and hush payments to facilitate and conceal crimes, pointing to a deliberate, organized effort. 5. Mann Act and transportation for prostitution. The government focused on flights and road trips with escorts, insisting the intent was illicit sexual activity, even if the acts occurred in private. Octagonal sign. Prosecutorial closing themes. He didn't take no for an answer. This refrain emphasized repeated episodes of refusal overridden through violence or threats. One example is enough. Jurors only need to find one incident where coercion occurred to convict on trafficking charges. Pattern meets enterprise. The prosecution tied physical offense, staff involvement, and maintained brand secrecy into a coherent RICO narrative. Scales. Implications for jury deliberations. Jurors are asked, did Combs behave as a criminal overlord, orchestrating coercive sexual conduct and using employees and resources to facilitate it? The government contends one single coerced freak-off is legally enough for conviction, even if others were consensual.